Being sovereign in court, part 4. Let's talk about it. All right, being sovereign in court. So you got to remember that the only reason for a judge ever was because there was a dispute in the public that could not be handled between the two parties. So when you're before the judge, he knows that there's a dispute that needs to be handled. When you do a private administrative procedure, what you are basically doing is you are creating an agreement between the other person that the claim does not exist anymore, or the dispute. What you are basically doing is you're creating a record that there is an agreement between the two parties. Now, because you are sovereign, you can invoke any of the 3 jurisdictions that there are. There is air equity, there is water international, and there is common law land. Each side has a private and a public side. The highest form of law is the private side of equity. There's also a public side of equity, private side of international, public side of international, private side of common law, public side of common law. Now, depending on what side of which law you are bringing in, if it's public, you want to record it into the public. If it is private, you want to do something called a letters rogatory and put it into the judge on the private side. It's called a filing, not a recording. When you do a private administrative procedure and it's on the private side and you file it into a letters rogatory to the judge, that gives him private knowledge that he then brings forward into the court case and basically knows that the judgment has already been created. Now, your typical court case starts off, they'll say, court case blah, 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 John Doe, and you stand up and say, that's me. But guess what? They're looking at an all capital letter U.S. citizen name when they say that. When you stand up and say that that is you, that immediately means that they have jurisdiction over you because you're admitting to be the U.S. citizen. You can say something like, you may refer to me as John Doe, or I am here in regards to that matter, or I'm the authorized representative for that estate. And remember that no matter what the judge says, it is a commercial offer and you have 4 different doors that you can go through. You always want to try to stay honorable to set off, settle, and close the account by moving the court to closure. If you are not competent and capable and fully grasp what is going on and have done studies, do not attempt to do any of this stuff. You will get hemmed up and get hurt. In my last video, any of those things you want to do when there is nobody behind you, you will upset the judge. His job is to protect the public, and the public is crazy, bankrupt, and wild. So if there's a line of people behind you when the case gets called, you want to say, is it wise to handle private matters in the public like this? If the judge says something like, what? Sit down. You say, would you like me to sit down? You have then given him knowledge that you know how to handle yourself and understand contract law. Because what happens a lot of times is people download documents offline, or their friend Bob, the jailhouse lawyer, tells them how to handle themselves in court. So when the judge gets paperwork, he's going to be watching you. He doesn't care what the paper says until you prove that you know what you are doing and how to handle yourself and present yourself proper. If he asks you questions and you're stuttering and you're fumbling and you're trying to thumb through all kinds of paperwork and you're making statements and you haven't reserved rights or know how to act properly, he's going to disregard all the paperwork and get you under his jurisdiction and fleece you like a sheep and get out of his court, or throw you in jail for the legal amount of time that the code's public policies and statutes that he is bound by allows for. Make sure your private administrative procedure is done in accordance with the Administrative Procedure Act, where you've given due process, and also remember that anything that is done outside of court is considered hearsay, even an affidavit. That's why it is very important to understand exceptions to the hearsay rule. Anything said inside of a court case stands as a fact if it has not been rebutted. If the judge says you were moonwalking with Michael Jackson yesterday and nobody rebuts or says anything, it stands as a fact.